Back on the record, this is the people of the state of Colorado versus James Egan Holmes, case number 12 CR 1522. The record should reflect that Mr. Holmes is present with Ms. Nelson and Ms. Spengler, and the people are represented now by Mr. Orman, Ms. Pearson, and Ms. Teach McGuire. Mr. Orman, before we proceed to the theory of defense proposed instruction, during the break I was thinking more about the discussion we had on lesser included offenses, and at the risk of giving everyone a headache, it seems to me that your argument would only apply with respect to the counts of first-degree murder, extreme indifference, right?
And attempted first-degree murder, extreme indifference. Yes.
Right. And so in that case, we would be giving the jury lesser included offenses that are different for the different counts. So with respect to first-degree murder after deliberation and attempt to commit first-degree murder after deliberation, I would be instructing on the lesser included offenses of second-degree murder and manslaughter. But then with respect to the counts of first-degree murder, extreme indifference, and attempt to commit first-degree murder, extreme indifference, I would only be instructing on the lesser included offense of manslaughter and attempt to commit manslaughter. And I meant to say with respect to the first set attempt also.
You know, Your Honor, I was actually thinking about that during the break, and I was, I think, too focused on the argument that tied it to insanity. And I am aware of precedent in Colorado that says that second-degree murder is a lesser included offense of first-degree murder, extreme indifference. And I still sort of agree with my, well, not sort of, I still agree with my argument regarding the insanity thing, but thinking about it more, because we have that case that clearly says it's a lesser included, I would rather, if the court is going to give any lesser included, give both of them rather than just manslaughter.
Okay. All right, that solves it for me, because I think I have to give it with respect to manslaughter, given the state of the case law and given the state of the evidence. And again, that's not a statement on what I think about the evidence or what I think in terms of how the jury is going to come out on this. That's just a statement based on what the law requires me to analyze at this juncture in the proceedings. So, and you
has the opportunity, if not the right, to present a theory of the defense instruction. However, the defendant cannot just present anything as a theory of the defense instruction. I would cite to a number of cases, and the cases discussing these concepts, Your Honor, are legion, and I've just pulled out a couple of recent ones. People versus Omwanda, O-M-W-A-N-D-A, which is 338 Pacific 3rd, 1145, Colorado Court of Appeals, 2014, and the pinpoint cite to the language I'm going to quote is on page, well, Your Honor, since we have these numbered paragraphs, I'll just give you those. Numbered paragraphs 40 and 41. It explains, Your Honor, that a theory of defense instruction must be general and brief and must explain the evidence and its legal effect. A defendant is generally entitled to a theory of defense instruction when the evidence in the record supports the instruction. A trial court must cooperate with counsel to correct an improper theory of defense instruction or draft an instruction that incorporates the substance of the defendant's theory. It goes on to say a trial court may reject a theory of defense instruction that is argumentative or merely highlights specific pieces of evidence. A similar language, Your Honor, is found in People versus Hart, H-A-R-T-E, 131 Pacific 3rd, 1180, from the Colorado Court of Appeals, 2005. And that, Your Honor, is found on page 1186 of that decision. And it says a jury instruction on the theory of the case that explains evidence must be general and brief and must instruct the jury on the legal effect of the explanation. It is not error, I'm skipping a sentence, it is not error for a trial court to refuse to give a theory of the case instruction that simply calls attention to specific points of evidence or contains argumentative matter. So in light of sort of that overarching law on what a theory of the case or theory of defense instruction is supposed to be, I will tell the court what my objections are to this. First of all, Your Honor, the entire instruction is improper in that it would read as the court finding and asserting specific facts. This instruction just sort of would have the court read to the defendant's own assertions about what his mental illness is. In other words, the first sentence reads currently in this instruction, Mr. Holmes suffers from a chronic and serious mental illness with psychotic features, period. The way this reads, it would be as if Your Honor is telling a jury that that's a fact. Theory of the case, theory of the defense instruction is not supposed to read that way. It should not read where it is interpreted by the jury that Your Honor is telling the jury that that's a fact, because in the United States, Your Honor, everywhere in the United States, judges can't tell the jury what the facts are. The facts are for the jury to decide. And I mean no disrespect when I say that, Your Honor. It's just not something that judges are supposed to do. So to the extent that any portion of this is proper and it talks about factual assertions, I would say instead of Mr. Holmes suffers or something along those lines, it would need to read the defendant, which is the name of the party. The defendant asserts that he suffers, etc., etc., or something along those lines, to make it clear that this is not some type of factual finding where the court is telling the jury that this is what the facts are. So that's one thing. Second thing is, Your Honor, the cases indicate a theory of the case, theory of the defense instruction should be brief. This isn't brief. This is pretty long. Also, Your Honor, it's argumentative, and a theory of the case, theory of the defense instruction is not supposed to be argumentative. So if we look at this, Your Honor, many paragraphs of the proposed instruction from the defense are argumentative. Let's start with the first one. I would say the first sentence of the first paragraph, if it is corrected to read, the defendant asserts that he suffers from, etc., that first sentence would not be argumentative, and I would not have an objection to that one sentence if it is modified as I said. The rest of it, Your Honor, is pure argument. It is essentially a pre-closing argument made under the guise of jury instructions. That is not the purpose of a theory of the defense instruction. This is just argumentative assertions by defense counsel in the guise of a jury instruction. Second paragraph, also, Your Honor, it's just part of an argument. It does not say, here are some facts that the law should apply to, which I think is what a theory of the defense instruction is supposed to say, which is sort of what we would get in with that first sentence there. Same thing for the third paragraph, Your Honor. It's pure argument. Fourth paragraph, I assert, Your Honor, pure argument. Fifth paragraph, I assert, Your Honor, pure argument, as is the sixth paragraph and the seventh paragraph. Although, Your Honor, I guess I'd be okay with the penultimate, which I think is the sixth paragraph's first sentence, if it started with the defendant asserts that his, as opposed to this sort of factual statement that the court is supposed to give to the jury. The last sentence, Your Honor, is not only argumentative, it's irrelevant. Maybe that's a factor that should be considered by the jury as mitigation in a sentencing phase of this trial, but this but-for thing, that's not the law. That's not the law in this state. That's not the law as included in the other jury instructions, and is irrelevant for purposes of the law. So there's two sentences in this, as I said, Your Honor, that I'm okay with, as long as they're modified so that they don't appear as factual statements on behalf of the court. Otherwise, Your Honor, I object to the rest of this instruction.
The second sentence that you're okay with, I think you said the sixth paragraph. Were you referring to the penultimate sentence?
Your Honor, you're right. It's the seventh paragraph. I apologize. It's the penultimate paragraph.
All right, so tell me the sentence so that we're all clear.
Okay. It's a sentence that starts with Mr. Holmes's delusional belief system, etc. It's in the second to last
Gotcha.
paragraph.
Okay.
So as long as that started with the defendant asserts that, I'd be okay with that sentence. So hold on one second. And Your Honor, I don't know if there'd be a title to this instruction, but I would request that there would be. I know that counsel put that in there, but I think that was probably just for convenience purposes so that we could differentiate it. But I would request that it actually say the defendant's theory of the case at the top. So it's really clear that this is something from the defendant, that the court is instructing them, and this is what the defendant's theory is. But this isn't the court's position, because the court has no position on any of these issues. Unless you have any questions for me, Your Honor, I don't have anything else to say.
No, I do not have anything. Thank you. Ms. Nelson, any response?
Yes, Your Honor. I am aware of the case law surrounding the defense's theory of the case instruction, and it's our position that this does comply with the case law. First, with respect to Mr. Orman's first objection that it reads as though it's a fact and that the judge is telling the jury the facts, we don't have any objection to adding something to the first, prior to the first paragraph that states it is Mr. Holmes's theory of the case. I do disagree with Mr. Orman that Mr. Holmes's name is the defendant. He has a name. His name is James Holmes, and so we would request that it would read Mr. Holmes's theory of the case. But I don't have a problem adding something that makes it clear that it's not the judge, it's not the court telling the jury, what to believe, but that this is our theory of the case. So I think that would be appropriate. With respect to his position that this is not brief, I disagree. I think that given the length and complexity of this case, this is a very brief statement and summary of what our theory is. I mean, this case has been going on now for about 3 months. We've been in jury selection since January. The case has been going on for 3 years. It's obviously a case with a tremendous amount of evidence. And so perhaps this would be a long, overly long theory of defense instruction if this were a simple burglary case that lasted 2 days. But given what type of case this is and the magnitude of this case, I think it's a perfectly appropriate in length. I disagree that the instruction is argumentative. The instruction is supported by facts that are in evidence, and to the extent that it recites certain facts, I mean, those are facts that have been elicited from witnesses. I don't think there's anything in this instruction that is factually inaccurate. And I also disagree. Just a moment, let me just check my notes here. I also disagree that the last sentence, with respect to the last sentence, that is irrelevant. Certainly, the role that Mr. Holmes's mental illness played in the commission of these acts is the central issue for the jury. And this is not, the purpose of a theory of defense instruction is to set forth what our theory is. Our theory, which is supported by the testimony of Drs. Reed, Metzner, Woodcock, and Gurr, is that Mr. Holmes's mental illness caused these tragic events to take place. That is what the testimony is, Your Honor, and if it wasn't relevant, then I don't know why the prosecution didn't object to that testimony being elicited. It's the position of all four of the psychiatrists who examined Mr. Holmes in this case, and it's certainly relevant for the jury to consider how and to what extent his mental illness factored into the commission of these acts. If I may just have a moment to confer with Ms. Spengler.
Yes.
I think just to revise what I said earlier with respect to putting something in, advising the jury that it's Mr. Holmes's position, I think instead of saying, our request would be to include language before the first paragraph that says, Mr. Holmes asserts that he suffers from a chronic and serious mental illness, and I'd take it from there. Rather than saying theory of defense, I think it would be more appropriate and more accurate to simply say, and simpler to say, Mr. Holmes asserts. And lastly, I would note, as the court knows, that if there's any part of this instruction that the court finds to be improper, that the court has a positive duty to cooperate with defense counsel to either correct the tendered instruction or to incorporate the substance of this instruction into one that's drafted by the court. So we would make that request, and finally I would rely on Mr. Holmes's constitutional rights to due process, to a fair and reliable sentencing proceeding, to a fair and impartial jury, as protected by the 5th, 6th, 8th, and to present a defense as protected by the 5th, 6th, 8th, and 14th Amendments to the United States Constitution and Colorado Constitution, Article 2, Sections 16, 20, 23, and 25.
Okay, thank you. My reaction was similar to what Mr. Orman said. It reads more like a closing argument than a theory of defense instruction. So I will look at it more closely over the weekend, and I will redraft it pursuant to what the law says I should do. I do think it makes sense to use theory of defense in the first sentence. That way we avoid having to use a title. I'm not using any titles on any of the other instructions. So I don't think it's appropriate to use a title on this particular instruction. But I think it is appropriate then after that to talk about Mr. Holmes's assertions or contentions or claims or things to that effect. But I'll need to sit down and try to figure out how to redraft it so as to make it an appropriate instruction. As tendered, I find that it is improper. This is not a proper theory of defense instruction. This is more a closing argument. In terms of whether to use Mr. Holmes or the defendant, to be consistent with the rest of the instructions, I'm going to use the defendant. That's what I'm using in all the other instructions, and I'm going to be consistent throughout. So the instruction is rejected. However, I will work on it and attempt to redraft it to make it appropriate and to correct it. And what I propose is that we plan to meet again on Monday at some point. I don't need everyone to be here, but at least one representative from each party to be here. So are the people available on Monday?
We are at your service, Your Honor.
All right. Is the defense available, Ms. Nelson?
Yes, sir.
Okay. What time works best for you folks?
1 o'clock.
1 o'clock?
As I was standing up, Ms. Tisha McGuire whispered 1 o'clock, so I'm
Okay.
going with 1 o'clock.
Is 1 o'clock okay for you?
My preference would be the morning.
Morning?
But
You want to do
I am
9 or
available.
10 or?
I'm instructed that that's fine, Your Honor.
Okay, what time? Do you care? 9, 10?
9.
9? Is 9 good?
That's fine, Your Honor.
All right, 9 o'clock on Monday. Okay, is there anything else we need to talk about at this time on behalf of the people, Mr. Orman?
Not on behalf of me, I thought we were going to talk about their argument about opening statements for the penalty phase, although I don't know if
that's
we'll do that
right.
Monday morning.
Yeah, you know what? Actually, the more I thought about this, the more I think I want to wait on this. So let's just wait. And I don't feel comfortable discussing it, especially right before closing arguments. I also don't feel comfortable having any discussions about this as the jury is deliberating. So just so that you know, I know that we had talked about maybe doing some work. It just doesn't feel right to me. I don't think it's appropriate to be having discussions about penalty phase while the jury is deliberating on the guilt phase of the trial. So we'll just wait. I know that the people have submitted some tendered instructions for the penalty phase. If the defense wants to submit a red line version of those instructions, that you can do that, or if you want to submit different ones to add to those, you can do that. I'm not asking you to reinvent the wheel, but I'm saying if you want to submit something ahead of time in terms of any differences that you have from the prosecutions, you can do that, but you don't have to do that. I'll leave it up to you.
We will be, Your Honor, and I have been working on them, and I regret to inform the court I probably will be reinventing the wheel.
Fine.
But some of them, I don't know, I'll have to give it some thought because we don't have a verdict yet. We don't know what the jury's verdict is going to be. There are a number of different ways that the verdict could come back given the different theories of murder alleged and whatnot. And so I don't know that I certainly don't know that I can submit all of my proposed penalty phase instructions before a verdict, but I can take a look at them over the weekend and on Monday, and I'm happy to get the court what I feel I can submit as soon as I can.
Okay. It's up to you. What I'm saying is what would be most helpful to me is, to the extent you can, is point out differences between yours and theirs, if that's possible. But if not, then I'll have to try to figure it out. I mean, there are a ton of them, and it's difficult to try to figure out where you differ. And that's what's important, or most important. There are no model instructions here. The law is somewhat murky in this area. It's not as clear as it is with respect to instructions on the guilt phase. So that's why I was suggesting that in terms of, I don't need to have, for example, if there's a particular instruction that the people have submitted, I don't need to have an identical instruction submitted by you if you don't disagree with theirs, just because it's included in your set. That's not helpful. To me, what's most helpful is to say, these are the ones we have an issue with, and these are the issues we have with them in terms of, that's why I mentioned red line, or even if it's not a red line version, even if they're separate, to say, these are the ones that we take issue with, and this is how we think it should be done on those that we take issue with, or these are the particular places where we have issues with the ones tendered by the people, something along those lines. But again, I'm not going to require you to do that. I'm telling you what would be most helpful.
I understand, Your Honor, and just so the court knows, we will be submitting our own set. That's what we feel we need to do to provide Mr. Holmes with effective assistance of counsel and to preserve all of his constitutional rights. I'm also planning to go through the prosecution's proposed instructions as well, and I can identify places where I object specifically, but I agree this is going to be a little bit trickier than the merits phase instructions, assuming that we do get to a penalty phase.
Mr. Orman, the ones that you submitted, what's the source for those? Does that come from prior cases that your office has done, death penalty cases, and have they been subject to review by the Colorado Supreme Court?
I wrote those up a long time ago, Your Honor. I'm trying to remember. Here's what I did. I contacted the capital case unit at the AG's office, and they sent me a set of instructions that they have. I modified them slightly, and obviously modified them so that they were consistent with this case, and looked up a few things on my own, and that's what I presented to the court.
Okay, well, and Ms. Nelson, what about your source, or do you know yet? Or does that just come from breakers that you have in your office from past cases?
Yes, I've been working from some proposed instructions that were submitted in other capital cases that our office has done, but mine they're not identical to any of those, but I've used those as sort of a baseline to get started. So.
Well, to the extent you can provide that information, if they've been scrutinized by an appellate court, then that would be helpful. I know that some opinions may refer to some instructions, but not necessarily all of them. But if they've been subjected to any kind of review, whichever one is being submitted by either side, it would be helpful for me to know. So.
What I will do, I don't know if this would be helpful to the court, but next week I will try to get someone to go down to probably the state archives and maybe try to pull records on cases that have gone up to the Supreme Court, and maybe just, if it might be helpful to the court if I could just get like the Dunlap jury instructions or the Harlan jury instructions and give a complete set that were subject to Supreme Court review. And I don't know if that would be helpful to the court, and just give the court a complete set so you can see what they look like.
Maybe. I don't know. It's hard to say. It might be helpful. All right. Anything else, Ms. Nelson, from you before we adjourn?
Yes, Your Honor. Well, two things. I would request to make my argument about why we believe we're entitled to an opening statement during any potential penalty phase now. We need to be able to plan, Your Honor, and obviously we don't know what the jury's verdict is going to be, but it's not like, we're going to be completely surprised and then put together a sentencing hearing in a day. We've obviously been planning all along, and so we need to be able to know, in order to provide Mr. Holmes with effective assistance. And so my request would be to submit this additional authority and make this brief argument now so that we can get this issue resolved.
Okay, that's fine. Tell me what the authority is.
Well, Your Honor, I looked, and then just so the court knows, I also have one other matter after this that I don't want to forget. I did some research, and I could not find any rule or statute in Colorado that explicitly affords parties in criminal actions an opening statement, but it's clear that the right to an opening statement in a criminal matter has deep roots in common law in Colorado. It's been cited in case law that goes back as far as 1904. I found a case, Mulligan versus Smith, from 1904, 32 Colorado 404, that discusses the rules for opening statements. And so it's clear that in a typical criminal matter, it's a very long-standing right under Colorado law. It's hard to imagine a court depriving a defendant of an opening statement in any ordinary criminal trial in the state of Colorado. The model instructions describe an opening statement and its purpose, and it's clear that an opening statement is contemplated in criminal proceedings in Colorado. And my argument is that a sentencing hearing, a capital sentencing hearing, has all of the features of a trial. We will be presenting evidence. There will be cross-examination. The rules of hearsay apply. There will be exhibits admitted. At the end, there will be a closing argument. The jury will be asked to deliberate, again, assuming that we get to a penalty phase, if we get to a penalty phase. But in every respect, it's a full-fledged formal criminal proceeding at which the jury will be asked to make the most important decision that a jury can be asked to make in a criminal matter. This isn't even just a question of whether Mr. Holmes would lose his liberty. It's a question of whether they're deciding the question of whether another human being should live or die. And so Mr. Holmes should be afforded all of the procedural rules and rights that a typical criminal trial has, given the heightened reliability that's required under the Eighth Amendment as well as Article 2, Section 20 of the Colorado Constitution. And I'd say to Beck versus Alabama, Gardner versus Florida, Woodson versus North Carolina, and all of the other cases that we've relied upon for that proposition during the course of these proceedings. I was only able to find one Colorado capital case that references penalty phase opening, which is Dunlap 3, which is the 2007 decision from the Colorado Supreme Court at 173 P. 3rd, 1054. And that was the point of the proceedings in which the case was on post-conviction review, and the issue presented was whether trial counsel was ineffective because of the arguments that he made during the penalty phase opening statement. So we know that an opening statement was given during that capital trial, and the argument was that counsel's statement was constitutionally deficient because the attorney promised expert testimony and studies that were ultimately not produced. And the court analyzed the issue and concluded that there was no ineffective assistance of counsel. But what was notable about the case to me is that the claim was resolved on the merits, and there was nothing in that court's opinion to suggest that it wasn't possible for counsel to have provided an effective assistance because the defendant doesn't have a right to an opening statement during a penalty phase of a trial to begin with. In other words, the implication that one can draw from that case is that Dunlap was entitled to a penalty phase opening and had the right to effective assistance of counsel during that opening, but that counsel was performed in a constitutionally sufficient manner. The statute 18.1.3 12011B capital sentencing statute in Colorado states that the prosecuting attorney and the defendant or the defendant's counsel shall be permitted to present arguments for or against a sentence of death. So that's a little bit ambiguous. I know that an opening is technically a statement and not an argument. But what an opening statement is a factual presentation of the matters that the party expects to prove, and the purpose is to help prepare the jury to better understand the evidence that they're going to hear. And so in a broad sense, an opening statement relates to a closing argument. An opening statement is the part of the counsel's case in which we're arguing against the death penalty. We're giving the jury a roadmap about why they might be hearing from certain witnesses. And it could inhibit the jury's full consideration of mitigation if we just start the hearing, start putting witnesses up, and the jury hasn't heard any kind of explanation from us, any kind of roadmap or introduction about why or what the purpose of this particular evidence that we would expect them to hear is going to be presented to them. I know this issue is when Ms. Brady first brought this issue up, there was some concern about us making reference in an opening statement to different phases of the proceeding or whatever. We're happy to do 2 short openings or 3 short openings, however the court wants to structure it, and limit our arguments or our statements to evidence that we intend expect to be presented during each particular phase. We can structure it however the court would like, but we do believe that we are entitled to this very simple, basic, long-standing right in a criminal proceeding, given that the sentencing proceeding has all of the features of a criminal trial that I discussed earlier. We'd rely on due process, right to a fair trial, fair and reliable sentencing proceeding, Mr. Holmes' right to the effective assistance of counsel, his right to present a defense, and right to fundamental fairness under the 5th, 6th, 8th, 14th Amendments to the United States Constitution and Colorado Constitution, Article 2, Sections 16, 20, 23, and 25, and the heightened reliability that is required because this would be a proceeding in which the prosecution is seeking the death penalty against Mr. Holmes. Again, all premised on the possibility that of a penalty phase in this case, which, as we know, is a possibility, but we don't obviously know how the jury is going to, what verdict the jury will render at this point.
Okay.
Your Honor, so what now the defense appears to be asking for is mini opening statements, numerous little mini opening statements for various phases of any potential sentencing phase in this case, but they have not presented the court with any authority that they have a right to that. The defendant has had an opening statement in this case and gave one in this case. The sentencing phase of this case is not a separate trial. It is a continuation of this trial. It is a continuation of these proceedings. There is no rule of criminal procedure nor precedent that has been cited to this court that affords the defendant the relief that he seeks. Also, Your Honor, I just think of this from a logistical perspective. I guess it would be easy if there were opening statements in the first phase, which we've presented all the evidence we need. We're not going to present any additional evidence in the first phase. Okay, so we would...
So you're anticipating only argument in the first
only
phase.
argument, so...
Right, so given that, Ms. Nelson, this is sort of more relevant to phase 2 and phase 3, if we get to phase 2 and phase 3, assuming there is a sentencing hearing, right?
Correct.
Okay.
So let's get to phase 2. Who goes first? And I don't mean that in the Abbott and Costello sense. I mean who goes first? Who goes second? Because as the court knows and as we've litigated, neither party has a burden of proof. It would be ridiculous, I would assert, for the court to make us go first because the defendant is going to present mitigation evidence first and we'll have an opportunity to rebut that. If the defendant goes first, does that sort of imply to the jury that they have a burden of proof because we went first in the guilt phase of the trial? I don't know. Also, Your Honor, it sort of puts us behind the 8 ball on this because the court, and I'm not disagreeing with the court's decision, I'm just stating that this is like the rules of football. I might want a 15 yards for a first down, but it's 10. The court has said the defendant did not have to give us statements from their potential expert witnesses, and there's at least one important expert witness that they even told us they intend to call, where we got nothing about what he's going to say. Nothing. So any rebuttal that we got to make up is going to be on the fly. We have our experts endorsed. They're going to watch. They're going to be ready. But we don't know what they're going to say because we don't know what the defendant's expert's going to say. So we would be expected to say, okay, here's what you're going to hear from us. We don't know. You're going to hear something. You're going to hear something from us on that point. But we don't know what it is because the defendant didn't give us a statement from this key expert witness that they have. That places us in an extremely unfair situation, Your Honor. Unfair situation. That's for Phase 2. For Phase 3, it'd be easier for us because we know what evidence we're going to present in the third phase, assuming the defendant knows. But then again, who goes first? I don't know. I guess the court could flip a coin or whatever, make a decision, because both sides are going to present their evidence in Phase 3. But the jury's going to hear it, and the jury's going to be instructed. And I don't think they need to hear, frankly, lawyers speak to them any more than necessary. What they need to hear is evidence, and they need to hear instructions from the court, and then they can hear our arguments. But counsel's right when she says arguments, opening statements are not arguments. And a statute that provides the parties with the opportunity to make argument does not afford them the opportunity to make an opening statement. So I don't think that it's necessary. I don't think that the defendant is entitled to it. I don't think the court would be denying the defendant any right, much less a constitutional right, by saying, well, let's just put on evidence in these phases. That's all I got to say unless you have any questions for me, Your Honor.
No, thank you. Well, Ms. Nelson, my understanding from Ms. Brady and from what you said just now is that the reason you're asking for an opening statement is to be able to tell the jury what to expect and to introduce the mitigation that you're intending to present and to be able to orient the jury in terms of what mitigating factors you're presenting evidence on. For example, this evidence goes to this particular mitigating factor. This evidence will go to this particular mitigating factor. That's how I have understood Ms. Brady's comments and your comments. And frankly, I think that would be helpful. I've thought some about this, and I think it would be helpful to have that. But it doesn't need to be more than something that's very brief, simply to introduce what's about to happen in general. And so I'll give you a couple of minutes to introduce your case in Phase 2, but you'll go first. The prosecution will go second. And then in Phase 3, the prosecution will go first, and you'll go second, and you'll each have a couple of minutes for opening statements as well. Again, just to provide a general roadmap about what you anticipate the evidence will be in that particular phase, assuming that we have a sentencing hearing, or in case we have a sentencing hearing and we get to that phase of the sentencing hearing. There's no need for opening statements in the first phase because the people are not going to introduce evidence and both sides agree that it's just going to be arguments. So it's just one set of arguments. All right? Okay, is there anything else? Ms. Nelson, you said you had one other thing. What is it?
Can I ask a clarification on one
Yes.
brief thing, Your Honor? You said a couple minutes. I'm assuming that means 2 minutes flat.
That's what I mean. 2 minutes, yes. Ms. Nelson, what else?
Your Honor, I just wanted to make a record that we renew our motion for judgment of acquittal now that at the close of all the evidence.
Okay. And for the same reasons that I denied it at the close of the people's evidence, it is denied now. It's the same standard that applies and the same reasons apply as well. And I incorporate by reference the comments Mr. Orman made in response to the motion, which I agreed with at the time of at the end of the people's case in chief. Anything else?
Sorry, I do have one more thing. We did confer a little bit about the exhibit discrepancies, and I have a couple of things that I can bring to your staff's attention. There were just a few pieces of evidence that were described one way in our chart, described another way in the court's chart, and if we could maybe have your staff like pull those pieces of evidence just so we can resolve any discrepancies maybe on Monday morning or something?
Actually,
We're
why
gonna
don't we
be
do
here
it
anyway.
today, and then that way, if I need to get involved, then I can get involved on Monday morning. That would
Okay.
be my preference. So if you would stay back for a little bit, I'll have my staff come out and talk to you folks, and then
Sure.
let's try to figure out where the discrepancies are, and then if there's a need to make a record on Monday, I can make a record.
Your Honor, I don't object to that in principle, but as Your Honor indicated, we don't have all the attorneys here, and one of them I think would be necessary for a couple pieces of the evidence. And also, Your Honor, our paralegal was the one who was keeping track of our exhibit list and everything, and I'd really want her to be here for this. And we sent her back to the office because there really wasn't anything to do. Actually, she went home. So I understand Your Honor's position, but my request would be to do this Monday morning.
Are you okay doing it Monday morning?
And I'm happy to email Ms. Robinson just to give her a heads up about which of the, they're pretty minor issues, but I just want to make sure we're accurate, so.
That would be helpful. Why don't we do it that way? And then Monday morning, have whoever needs to be here for that be present. Okay? All right. The court will be in recess. Thank you, everyone.